Right, good afternoon. Thank you very much for joining us. My name's Ashley Bowes, and together with my colleague Ruchi Parekh, we'll be guiding you through the top tips for success at virtual planning events. I'll be dealing with virtual planning inquiries and local plan examinations, and Ruchi will be dealing with the planning court and how to best advance your case in there. This is the last of our planning week sessions, so if you've joined us for others throughout the week, thank you. We hope you found them informative and we've loved having you. This webinar will be available to download and view after the event on our website in common with all the others, and Ruchi will explain the details for that when we get to the end. So, starting off then with appeals and local plan examinations. Where are we? Well, we've gone from this, and anybody from Braintree District Council will recognise that this is one of their inquiry venues, so photo credit to them. We've gone from our familiar trestle tables in village halls to something a bit like this, which is the familiar now Microsoft Teams interface, which is how all planning inquiries, local plan examinations, hearings are being progressed at the moment. There are no in-person sittings. There had been a proposal to have some blended events, and there had been a proposal to have some face-to-face events later on in the autumn, but those, so far as we're aware, are now no longer taking place. So there's a number of features to just talk through about how virtual events are different. First of all, we've noticed that there's certainly a lot more case management that's required, a lot more time to be put into thinking about how the event will progress. Secondly, dealing with cross-examination and marshalling documents through a screen is tiring and time-consuming, and so the aim of most planning inquiry events, planning inspectorate events, is that they should comprise 3 90-minute sessions. Some, however, unfortunately have gone over that time in order to accommodate the event within the programmed timetable. And the third characteristic that we've noticed of these events is that they do require significant document management, referring witnesses to documents and taking them to the right page needs to mean that there needs to be a central, well-organised, publicly accessible document library, akin really to a local plan examination library, and that takes a lot of forethought. So what to think about before the event? Well, the first thing to think about is, should the event be virtual? As I said, at the moment, it isn't an option to have an event face-to-face. So if you're in the realms of thinking that it's inappropriate to have a virtual hearing because, for example, the evidence is highly complex and factual, and it may well mean that the people giving that evidence aren't able to join virtually for whatever reason, you're going to be looking at a very significant delay before your case is then relisted. The government is placing significant weight on keeping the system moving, and there's a written ministerial statement from the 13th of May, which explains that the presumption is that events should proceed virtually and expects everyone in the process to engage proactively. And therefore, it really does follow that it's likely to only be a very tiny minority of cases where the planning inspectorate would accede to delaying an event being programmed pending the resumption of face-to-face hearings. Second thing to think about, therefore, is that once you've settled on a virtual hearing, it is how are the documents going to be accessed electronically, both at speed during the event in order to prevent delay, and also by members of the public who have an entitlement to not only view proceedings, but be able to participate meaningfully within them. What this really means is that you need to think about investing in document management software, which enables hyperlinking and bookmarking. Also, if you're for the appellant, think about liaising early on with the local planning authority about who's going to host the documents. Not all planning authorities will have systems to host documentation, and therefore it may well be necessary to have a separate inquiry website set up, either hosted by the appellant or some neutral third party. The planning inspectorate won't offer that service. Third thing to think about is, well, where are you going to conduct the inquiry? Can all your team be safely accommodated in one place? It's certainly my experience that if you've got a number of witnesses and a large team, it's certainly better to be all in the same location, obviously appropriately distanced if you can, but it's very difficult to keep track, especially in an inquiry with complicated evidence that crosses across a number of witnesses' areas, to deal with all of that entirely remotely. If you cannot, of course, be accommodated safely in one place, you'll need to think about a sensible way of communicating during the event. You could use your email function, although it does present the difficulty that the notifications can then interfere with the audio. And so what I've done with the teams that I've had in virtual inquiries is to use just a WhatsApp messaging service, or other instant messaging services, of course, available, but that seems to work very well, and that it enables groups to be set up and people to speak without then interfering with your contact with the screen. I'd also recommend starting the dialogue with experts early, and we know that, of course, post-Rosewell, that is the direction of travel, both to have topic-specific statements of common ground and also Scott schedules, which identify the principal issues which are in dispute, and a summary of each party's propositions on each one. After the exchange of evidence is really a good time to take the lead on a Scott schedule, because whichever party you're for, the appellant or the planning authority, the party that tends to be proactive tends usually to then define the scope of how the issues are articulated and how they are then dealt with in the inquiry. It's quite rare that the inspector will interfere very much with how the respective parties have defined the issue. So if you're the one that gets in quickly and defines the issues through a Scott schedule, then you're likely to gain the advantage of having the evidence come out in the way that's most beneficial to you. Also important now to remember to put some time aside to participate in the short test event that the planning inspectorate will require, usually a week before the inquiry starts, usually only about 10 to 15 minutes, although some inspectors also like to use these sessions to deal with some sundry case management issues. So do make sure that your advocate is available and present for that, or somebody else, planning consultant or the planning officer, who's properly informed about all the housekeeping and substantive issues to answer and deal with any questions that arise. So you've had your run up to the event, and then you're finally there in the slightly anticlimactic setting of either your office or your kitchen. What to think about during the event? Well, first thing that's important, I think, is to think about a protocol that you can agree with the other side as to how witnesses are going to give their evidence. If you're all in the same building, I think it's unwise if the witness and the rest of the team are all in the same room whilst the witness is giving evidence. I don't think it gives a very good impression. And also on the practical level, there can well be some feedback and audio problems. So I think it better to set a witness aside in a separate room for them to confirm at the beginning of their evidence that they're alone in that room and that they've switched off their email or telephone and WhatsApp messaging services, just so it's clear that the evidence is being given in the same way that it would be given in an inquiry, and that there's no suggestion of prompting or coaching or any interference with the quality of the evidence that's given. And it's a good idea to set that up with the other side straight away. When a witness obviously isn't giving evidence, as I say, it's important really to make sure that your whole team has a secure means of communication if you're not in the same place. One thing you won't be able to do is use the messaging function on Microsoft Teams. First of all, the Planning Inspectorate don't allow you to do that, although technically they're not able to switch it off, and that leads to quite a lot of disruption sometimes at the beginning of an inquiry when members of the public like to give some feedback on how some of the cross-examination has gone. In my last session, there was some rather entertaining comments in the comments section, but you shouldn't use that for obvious reasons. Secondly, the other pretty important reason is that the person who hosts the event, so in this case the Planning Inspectorate, they get a whole copy of all the comments that have been transcribed in the Microsoft Teams session, so very careful what's said. So just avoid that altogether, have your own separate way of communicating with people. Circulating documents during the event really is very time consuming and can cause a lot of delay. So I would suggest that all new documents that you want to put in, including opening statements and closing statements and additional planning appeal decisions or case law, that you put that in well in advance of when it's likely to be needed. And that's something perhaps to flag up with your inspector. It's important to remember that virtual events, whilst they are becoming far more common, in fact, the day that this event took place that you're looking at 2 weeks ago, there were 27 virtual events that the Planning Inspectorate were hosting on that day, ranging from DCO examination, Section 78 appeals, and local plan examination. So they are becoming far more familiar. However, in the last 3 inquiries I've done, and the one that's starting in 10 days' time, the inspector has not previously done a virtual event. So it's important to remember that the person that you're in front of may not be expert in all the technical elements of it, and they may not have experience of it. So try to be proactive about some of the things that may be problematic to make sure it runs a bit more smoothly on the day. And one of those things I've found is certainly making sure the documents go in as soon as possible. So send your openings on the morning of the first day by agreement with your opponent, closings the same, any additional documents, make sure they go in as quickly as possible. But apart from that, I have to say, and I hope that people who've participated in them will agree, that it is a bit like those pilots who do their virtual sim events once every couple of weeks to make sure they're still on track and capable of flying an airplane, that once you get in there and you start toing and froing with a witness and cross-examination, in essence, you forget that it's a virtual interface and it has worked generally quite smoothly. And I think the inspectorate really should be congratulated for progressing with this system and getting it going, because the idea of the Planning Inspectorate holding all their events virtually this time last year would, I think, been largely unthinkable, and they really have adjusted very quickly. So that's all I wanted to say about virtual planning appeals, and I'll hand over now to Ruchi to talk about the planning court. Ruchi.
Thanks, Ashley. That's really useful. So as I take over from Ashley at 2:15 on this Friday afternoon, I fear I've really drawn the short straw with this virtual graveyard slot. But here we are, and I am going to talk quite briefly about the state of affairs with the planning court hearings. So now, some of you may yearn for the long lost days of a trip to the RCJ on a crisp winter's morning. Perhaps you even miss your Pret coffee and croissant from across the street as you leisurely make your way to court. Sadly, however, most of my court outings always looked more like this. And now I thought I had repressed the memories of my worst commutes to court, but they all just came flooding back as I was preparing for this talk. And there is nothing quite like the stress of hearing the words signal failure, or indeed leaves on the track at 7 a.m. before a full day admin court hearing, particularly if it's in Leeds. That being said, the world has changed around us quite dramatically, and it has also changed the way we work. And while it's quite difficult to find silver linings in this crisis and pandemic, I, for one, am grateful for the rise and acceptance of the pajama suit. So now, that's clearly not how I approach my practice, although of course you'll never be able to tell. But as I suspect you all know now, the planning court is continuing to hold cases remotely. The Court of Appeal, until last week at least, was giving parties the options of coming in person, but socially distanced. And I'm not quite sure if that's continuing through the second national lockdown, but I suspect it may well be, because the courts are still exempt from the strict rules. So if you are preparing for a planning hearing, what do you need to think about? Well, the first thing is the up-to-date court guidance. There is now a whole host of guidance available, and in particular, there's two documents that we think you should look at. So first, the Admin Court Guide, and that's on the COVID-19 adaptations. It applies to the planning court. It deals with the logistics of filing claims, issuing claims, responding to appeals, fees, that sort of thing. There is also the protocol on civil justice in England and Wales. And again, this is a protocol for all remote hearings. Now, all of this is set out in more detail in our paper, which I believe has been circulated. So I would ask you to look at that. And it also has the links to the various guidance, etc. The next thing to think about then, and this is really focused quite heavily, is the focus of, basically all the guidance, which is electronic bundles. And this is, in my view, the biggest takeaway from the guidance. So the Admin Court Guide, for example, states that there will be sanctions for non-compliance with the new rules on electronic bundles. So what we do say is, do read the rules, don't get it wrong, because there is nothing worse than annoying your judge even before you've started your substantive arguments, simply because the pagination on the PDF bundle doesn't match the pagination on the pages. And trust me, I have been there, it's not pleasant. So I appreciate this is really boring stuff, but just make sure you know what the rules are and do try and get it right, because it just avoids, the drama, unnecessary drama that you could have first thing before you start your case. And then finally, as Ashley's already mentioned, in relation to the local plans and inquiries, etc., is do think about your location. So think about whether you can all be in the same room, and that might be, if you can be suitably accommodated with appropriate procedures, etc., that is obviously beneficial. That being said, in most of my hearings, I have, like Ashley, just used WhatsApp groups for communication, and I found that they've worked really well. I wouldn't really advise emails for the reasons that Ashley said, and also it's not as instant as communication as WhatsApp, for example, or other services like that. Right, so while we are on the topic of top tips, I thought it would be useful to also run through the top tips on remote hearings that were issued by Mr. Justice Holgate quite early on in the lockdown. So the six tips are on the slide, and I'll just go through them. So the first one is succinct skeleton arguments, agreed reading list, and a good skeleton argument really that's properly cross-referenced to the bundle. So if you instruct someone from the Cornerstone planning team, we're all over this rule, we'll take care of this one, and you don't need to think about it any further. The second rule then is the bundles, of course. So stick to the material that is really essential to the legal arguments and try and agree a slim, kind of minimalistic core bundle. The courts really just hate when you have lots of different documents in there, and it just makes navigation more difficult for them, particularly when the judges are relying on an electronic bundle. The third tip then is bundles again, but this is authorities bundles. Again, we will be on top of this rule if we are instructed, so you don't need to think about it. The fourth tip, what a surprise, bundles again. And what Mr. Justice Holgate says is that the court wants to see a good index, continuous pagination, and working hyperlinks. So just keep those things in mind, and do try and get that right. The fifth one is a bit of a weird one because I didn't really think it was a rule, but it just basically says that if you follow the protocol, you will make the judges' lives easier when they're writing their reserved judgments. So I guess that's good to know, and that's something to keep in mind. And then the sixth one, and I think this one is really quite important, it's a plea to keep the merits of your case under review and to essentially abandon hopeless arguments as early in the proceedings as possible. Now, I think this is a good tip for all cases, not just for virtual hearings, because it really does leave more time to give proper consideration to your strongest arguments and, just avoids annoying the judge again, which is key. So as I've already said, all of this is in our paper, along with all the other recent cases and changes to protocols, etc., that touch upon virtual hearings. So please do have a look at those when preparing for your next hearing. One thing that I will flag before I move on is that the various guidance on electronic bundles, at least, has been collated and set out by David Elvin QC, sitting as a Deputy High Court Judge in the Thurlow decision. And this, again, it's referenced in our paper, and it's quite useful because I appreciate there's lots of different strands of the guidance, and it's really brought together in that judgment. So it provides a good sort of tick box exercise if you want to make sure you haven't left any ground uncovered. Right, so that leaves me then with the actual hearing. And I think in general terms, it's safe to say that it's not that different from in-person hearings. And this comes back to what Ashley was saying as well in his part. There are obviously some things you need to think about to make sure your communication channel is all set up properly, adopt the usual etiquette of virtual meetings. So, for example, mute yourself if you're not speaking, make sure you have a quiet room, etc. Ensure that at least the top half of you is presentable in appropriate court attire. And other than that, I really do think it is a case of business as usual. Which brings me quite promptly to the end of our kind of substantive talk. But at this stage, we'd be very happy to answer questions. And I might just hand over to Ashley to kick it off because I can't seem to see where the questions are on this Zoom.
Well, I think we've had one suggestion rather than a question, which is very helpful. And I won't say the name, but just to say thank you very much for writing it in, because I understand that presents us with regulatory issues. Is to say that in my recent PI public inquiry last week, we used the chat function in Zoom to communicate between the team. I found this easier than WhatsApp, as I'm not as quickest on the smartphone. That's fine. I think all I'd say about that is that you probably want a different device to be doing that on, because running Teams and Zoom, certainly on my computer technology, might well be running it a bit too close to its processing capacity. So good idea, whatever works best for you. I think all I'd suggest is that you maybe have a quick dry run with the team before you get into the event proper. Because if you've certainly not done it before, it does take a little bit of time just to get into, to see how it all works. And really, with a public inquiry or a court hearing, you don't want to be thinking about that. You want to be thinking about the substance of your arguments and responding to what the other side or the judge or inspector is saying. So the more you can take that, the sort of technical worry out of it by practicing the week before or 2 weeks before or whenever you have a con, the better. So if anybody else would like to ask any questions or have any queries for us, just ask them in the Q&A function at the bottom of the screen. And we'll just give a few minutes for those. Or if not, our emails are on the slide on the screen now, and we'd be very happy to answer any questions that spring to mind later on. And I think, Ruchi, you were going to explain how you can access our talk.
Yeah, of course I will do. Yeah, I don't think we have any more questions. I mean, hopefully it's because we've given such a brilliant presentation. Oh no, there's a question, sorry. How are you finding cross-examination? Ashley, do you want to kick off on that one?
Yes, certainly. That's a good question. I think it's very similar to real life. The only thing I would find, I mean, obviously it is real life, it's just through a virtual prism, obviously. But the only thing I find quite strange about it is that credibility issues about when someone's not answering the question, which are very obvious in the room when you're all there at the time, are slightly more nuanced over technology, because sometimes people just frankly haven't heard what you've said. And you've asked a question and they reply Tuesday or something, and you think, well, what did you genuinely not hear, or are you just being obstructive? So sometimes that, if credibility is an issue, I think that's where that presents a bit more of a challenge for the planning inspectorate dealing perhaps with enforcement appeals, where there's factual dispute or rights of way inquiries, village greens, those sorts of things are a little bit more tricky than if it's expert evidence that's being given, where someone's giving an opinion. So I think that nuance, that sort of body language and interface is a bit harder to read people over the screen than it would be in the room. I don't know what you think, Ruchi. Has that arisen in?
No, likewise. I found that a bit difficult, because I think witnesses can get away with a little bit more, if that makes sense, by just kind of playing up the awkwardness of the interface, etc., or I think it's a little more difficult. But that being said, I think for the most part, I have found that it's fairly similar. You obviously, you go maybe a bit slower to make sure everyone's looking at the right document, etc. But other than that, I'd probably echo what Ashley has just said.
And I think we've had a further question, which is it the case that all appeal hearings listed for, say, January 2021 will be virtual or delayed? And the person who's written in, thank you very much for your question, and said that you've checked with PINS and you're told that it was still underway. As far as I understand it, PINS took a decision in March that they would adjourn all hearing or prevent all hearings that were timetabled for being in person, and then would relist them virtually. And that protocol lasted until November. And I have an inquiry next week, and that's proceeding virtually. So I assume that's obviously been reviewed and they've decided to keep them all virtual. As to how long that review is, I don't know. I think you might well get a slight indication from the Chancellor's furlough scheme extension till March that we're looking for certainly another good couple of months of this style before we'll start to come back to something else, obviously depending on where we are, in the immunology of all of this, but I don't think we're going to be returning to in-person hearings anytime soon. So if you had something listed for January 2021, I would be prepared for it to be virtual.
There's another question from Stephen on do we envisage legal challenges due to the use of instability of technology, etc. I mean, Ashley might have his own view. I don't see this particularly becoming, a ground for legal challenge. I mean, obviously it depends on what's happened or what's gone wrong in an individual case. My experience so far, particularly, I have more experience on the planning court side, is that things are being dealt with quite fairly, where connections have been dropped, allowances are being made for that. I've had lots of instances where, new points have been raised or something new's cropped up and I've had to take instructions, for example, and it's very much understood that you can get extra time to do those things. And so I feel like the courts and PINS are probably being as accommodating, and if something went seriously wrong, I would have hoped that they make allowances for that. I would be surprised if it would then, was handled so badly so as to give rise to some sort of ground of, I don't know, procedural unfairness or something like that. Ashley, what's your view?
That's absolutely right. And I think also the courts are going to be extremely reluctant to be seen to be giving any kind of support for the idea that, generally speaking, a virtual event is less fair or less robust in its conclusions than an in-person hearing. I think that would give rise to such instability in court decisions over the last 6 months and probably a good year that they will approach that with a great deal of scepticism. So, as you say, unless there was a very clear-cut example of unfairness, then I think the general fact that it was online or virtual is not going. You're not going to get off the starting blocks. And I think there have been applications to adjourn planning court hearings on the basis that it would be, broadly speaking, unfair to be virtual rather than face-to-face, and those have been very robustly rejected at the case management stage by the planning court judges who've heard them. And I think we have some more. So someone's written in to say that their understanding is that there'll be no physical events from the planning inspectorate until April 2021 at the very earliest. That's really useful to know that. I wasn't aware they'd taken that decision, but I mean, that would broadly be in line with, you know, practically speaking, where we are with society generally, wouldn't it? So that sounds about right. And then a question from my planning witness for next week. Just read what that says first before I read it out. Are all virtual inquiries here to stay for long-term post-pandemic? Well, I think that's a really good question, actually. I think there are certainly aspects of all of this, as you've said, Ruchi, both in the court system and in the planning inquiry setting, that have actually worked quite well. You know, the notion of sending fairly junior lawyers to go halfway across the country for a 10-minute application, as has been the way things have been done for a long time, I think that will go, and I think there will be far more use of technology, not least because it will save substantial cost to the parties and the court service. So I think we will have to learn to live with an element of this technology in our lives. I understand the courts for substantive hearings are quite keen to get back to in-person events, but the planning inspectorate less so. But I think in the longer term, we will see more of a blend of things, and it will mean that, for example, where you've got those classics or written reps appeals, where then some issue develops that, you know, like 5-year land supply suddenly becomes quite important, and it might then open up into a hearing, especially remembering what PINs have decided in the summer about having blended style events. I think there'll be a lot more scope for keeping it as a written reps appeal, but then just having an hour's roundtable session on Microsoft Teams, for example, rather than convening an event, because practically speaking, by the time you've convened an event and everyone's got there, you've lost the whole day. So I think there's going to be a role for this to play in both the courts and the planning inspectorate events going forward, certainly. And I think we've had a final question about have a large inquiry in January. It's going to attract a lot of public attention. Can anyone suggest ISP, as we simply don't have the capacity to host it ourselves? Those we have approached don't seem much interested in a one-off, even if it is for 40 hearing days. I don't know, I haven't got the technical knowledge to answer that question. Yeah. I don't know, Ruchi, if you...
I'm afraid I don't either. I think Anne has come in to say that for their 40-day inquiry, they're looking at a blended event. Yeah, I'm afraid that's not something that I know enough about.
No, sorry.
If anyone in the audience has experience or has suggestions, you know, please feel free to come in and weigh in. I'll just wait a few moments to see if there are any more questions that come in.
I mean, one of the interesting things about the system that I thought would happen, which hasn't happened by having them virtual, is the demographic of people who participated in planning appeals would start to change. But it hasn't really. Certainly the ones I've done, they seem to be very much the same. People who've got slightly more time on their hands during the day than otherwise. I think there was some thinking that actually there'd be a positive effect of more working people being able to log in and just make their points rather than having to take a whole morning off and try and be accommodated. But so far that doesn't seem to be the case.
Yeah, but I think if I just kind of also just share some musings, but for certainly one of the questions about the long-term kind of post-pandemic effects, what Ashley was saying about costs, I think is really important. And I think that is something that we would very much welcome. And the conversations that I've had with clients, for example, particularly around permission hearings, it just saves up so much time, especially if you're in one of the regional high court divisions, not just for yourself, but also, for the planning officer or your client or whoever it might be. Not everyone has to take a train and travel halfway across the country, or even for half an hour, whatever it is. You can just log in for your 45-minute slot and then go back to your day quite easily. And I think that is something that a lot of people feel quite strongly about, in the sense that these are some of the features that we should retain even in a post-pandemic world. Right, okay, well, I don't think we have any more questions. So I think that brings us to the end of Planning Week. I just wanted to say a very big thank you from all of us on the Cornerstone Planning team. It's obviously not been the same without the face-to-face interaction and the chats over coffee, etc. And, I, for one, have really missed the biscuits. But having said that, I really do hope that you have all enjoyed the sessions. And as Ashley mentioned at the start, all of them are being recorded, so you can access them online on our website shortly. And as ever, if you have any questions, please feel free to drop, individually one of us a line, or indeed our clerks, and someone will certainly try and help you. So again, thanks very much, and we hope you have a good weekend.
Yeah.